Hi everyone, thank you for visiting my website. This is going to be a relatively short video and it's going to be on one specific topic, but nowadays is probably the most important thing you can understand and know with regard to litigating a custody case. And this is for you, the future litigant, to understand. Text messages, emails, Facebook posts, Instagram posts, Snapchats, Twitter posts. You need to know that it is all admissible in trial. 15, 20 years ago when I was trying these cases, we never had this. It was one person would say something to another. Maybe we would have an email here and there that we would use at trial. Nowadays, when you go in front of a judge, we have stacks of emails and text messages and Facebook posts. What you need to understand is, one, everything that you have said and texted and Facebooked in the past is going to be admissible information. So you need to understand that and be aware of what you have said and done in the past, and you better believe it's going to be used against you if it was bad, and it's going to be used to your benefit if it was good. The only thing I can do at this point to help you is to say to you, every single time you text with the parent of your child or with your spouse, you need to understand that is admissible evidence and it may be used against you. And a lot of times, people go to attorneys and they actually tell their clients, why don't you send this text and see what kind of a response you get, and then we'll use it against him or her. So what I'm telling you from this point forward, if you even think you're going to litigate a custody case, a divorce case, be aware that every text message, that every email, that every Facebook post that you make is going to be used against you. Therefore, the best thing to do is, texting and emailing is pretty much a necessity, but in terms of social media, the best thing that any lawyer like me can tell you, get off of social media at this point. There's no reason to post how well you're doing with your new girlfriend. There's no reason to post even pictures of your kids, because things can be taken out of context. While you're in litigation, the best thing that we can tell you as lawyers, because we've seen it in court and we know how things can be taken out of context, we know how things can be abused, don't do it. Don't use social media at this point while you're going through this situation. And with regard to text messages and emails, be extremely careful. Every single time you send something, you need to know that that is going to be seen by a judge, and unless it is something so clear and so direct, you better be careful about what you say. And that's the best advice we can tell you with regard to text messages and voicemails as well. A voicemail is admissible at trial. Videos can be admissible at trial. Even recording phone conversations, there are limitations to that. There's wiretapping laws and things like that, but you'd be surprised. The answer to your question is it admissible? Just assume that it's admissible and don't say anything that you know you shouldn't say or you might think you shouldn't say. So that's the lesson for the day. Tip of the day from Rubin Law Firm, from David Rubin. Be really, really careful about what you email and text from this point forward, and stay away from social media until this thing is over with.